Hi everyone, how are you? I hope that you are doing well. Let me see here. We will get you something to look at while we're talking. We could do that, and we could do that. How about that? Oh, hi. There. We'll just have the Wright County Justice Center sitting there while we're talking. How about that? That's where the justice is going to happen, right? There we are. Okay, so, that looks like the part of my shadow. My shadow is awfully large. I'm not quite that large. Let me see if I can get a little better in there.
Everyone, it's Tabitha Jane. I am here at the Wright County Justice Center.
There we go. We'll do it like that. It is funny because in my shadow you can see I look like I'm 500 pounds with a bun on my head. A messy bun at that. I didn't have time to do my hair that day. That was the one I did the journalist thing. So anyway, this is my original content. And that being said, I will still cite the fair use doctrine. And I will do this under the Fair Use Act and disclaimer in Section 107 of the Copyright Act of 1976, where allowance is made for the fair use under the Fair Use Balancing Act, stating that a small portion of original material is used. New work is critique, satire, or education. The commercial value of the original is not diminished, and new work is predominantly original product of use. And I sourced that on YouTube from Emerging EdTech and Termly. So, I think that the bots want to hear fair use, fair use, fair use. So fair use, fair use, fair use, fair you. I do listening on my channel, so save me to do me later, babe. No, kidding. Listen while you work, make banana bread, dribble, shower, all of the things that you do when you just want to listen and you don't have time to sit and watch. That's what I'm there for you for. If you like me, please like and sub. See my work, please drive people to my channel and say where it's from. I'm going back to square one here. I just did an intro kind of explaining how my channel and the coverage of Katie Joy is going into this new year with a different direction and goal. And I want to go back to what happened in that hearing back before Christmas, where I did 30 pages of notes. I did talk about the first 10 pages, but I still had to withhold details because there were certain things that went on in that hearing that if I would have talked about, it could have negatively affected something. I'm just going to leave it at that. That's that. So we're going to go back. We're going to look at this. Everything has been ruled upon. There was arguments made from both sides. The judge ruled on what was argued that day and came up with her order, and that order was, let's see here, she ruled on that on the 29th of January, and the items argued were brought in front of her to then be fully evaluated at the live scheduling conference for March 19th. Now she, surprised everybody and came through with her ruling on motions to compel for certain orders on the 29th. If you look at the deadlines, that the motions to compel, in my understanding, should have been completed then by the scheduling date. What do I know? Nothing is happening as it should be. So, came into court. As we talked about, Jennifer Moore came in at 9:53. Court was scheduled to start at 10. Jennifer Moore went to the right side, which in that courtroom is mainly for the plaintiff. I understand that different courtrooms can have different sides, but it was my experience that the right side is for the plaintiff customarily. Jennifer Moore was not. Jennifer Moore is the defense for Katie Joy, and she was not aware of that. So she came in, she sat down on the right, and the bailiff and I kind of looked at each other like, And then she's like, oh, am I in the wrong place? I can't ever remember which side I need to sit on. So she went over to the other side, and then the plaintiff explained that the reason for in that courtroom is that the defense goes for the left side because they've got the door there so they can bring in a defendant if they are incarcerated. So that made sense. So now we know that in that courtroom, the plaintiff is for the right and the left is there. So I can tell you that when she came in this time, late, again, on April 11th, she had car trouble. She did know to go to the left, but Xena Warrior Princess, aka 7M's attorney, was already sitting on the right. So, and I sit on the right too, just because, you know, I'm a giant nerd and I am the one attending because Katie Joy doesn't attend. I do. So, we were sitting there. And Amber came in at 9:56. She is still on time. 10 o'clock is when it was supposed to be. But they were kind of starting to ask questions because, you know, in a court that, you know, 15 minutes before is when you should be there. If you're there the minute it starts, you're late. So anyway, then they summoned the judge and we stood up and everything was ready to go. Jennifer Moore was dressed in her kind of black slack, kind of Maggie Barnes kind of two-piece suit. Maybe a Vera Bradley bag, kind of, you know, just right in there. Like I say, she's a very nice lady. And Amber was wearing her court attire, which is a bodycon dress, no nylons, and a jacket. And like I say, if you look at that right there, you've got modern LA, kind of, you know, dressing edgy for the court. And then you've got your classical modern over here, where you've got Minnesota. There you go. Okay. Both could be argued that they are wearing business casual. I would have worn more of an elevated outfit if I was an attorney, but that's me. Okay. I had all my little suits and everything when I was a legal beagle, but anyway. It's a different world, and I need to adjust to that. So, we're going over here in that same modern versus old. I mean, new. Oops. Amber has her laptop, and she's pecking away, and Jennifer Moore has her paper and pen. I have my tablets that are personalized with little cats all around it, because I can do that, because I'm not working for anybody but myself. It was silent. You could have heard a pin drop. No eye contact between the two attorneys. They didn't greet each other. Nothing. Tick tock. Tick tock. 10:03. 3 minutes had passed. You could hear a pin drop. The tension was palpable. Okay. And 10:09. All rise. Judge is in court. There we are. Jennifer Moore had her nails done nicely. Amber did too. I checked. Well, And then we were seated. And the judge states, okay, who do we have here? You know, introduces herself, you know, make sure that each side is there. Jennifer Moore is for Katie Joy. Amber is there for 7M. And she says, okay, so basically we have, you know, outstanding items here. We've got a lot. We've got discovery, and we've got interrogatories, and we've got a lot. And at that point in my head, I'm going, okay, what's the difference between interrogatory and discovery? Oh, I couldn't remember. And so I looked it up at that point too. And so I probably just did a Google search, but I kind of doodled that too, where interrogatories, basically think that interrogatories are more intense one-on-one questioning. Well, that's it. Okay. An interrogation is where you're being questioned. An interrogatory is written questions that are given during the discovery phase. In simple civil terms, and that was from JP LawNet. In simple terms, according to Cornell, an interrogatory in a civil procedure is a list of written questions one party sends to another as part of the discovery process. The recipient must answer in writing under oath and according to the case's schedule. Okay, so there you go. That's what Cornell says. And that's where, because I was going, okay, it's been 25 years. Can I remember back to why these are different? I really couldn't. And it seemed like they were using the terms interrogatory and deposition interchangeably. If you remember that day where Katie Joy said that she had to not be a mom or be a, I don't know. Basically, she was not able to live stream in her diaper for a whole day. Many thought that it was for the Tati. Me looking at the 7M and knowing that there was a time where the interrogatories were, I assumed that it was for this case. Others assumed that it was for the other. And I think that it came out that she did something for the other. So you may have been right, and if that is, I don't know when the interrogatories took place, but I have the copy of them, so we will refer to them. And the judge said, okay, Amber, do you want to go first? And Amber says, yeah. That, you know, basically in the interrogatories, we've got 4 main arguments that need to come out. And in the interrogatories, number 9 can be waived. Okay. And so number 9 was produce any and all drafts of social media posts that you have made regarding 7M Films Incorporated. Okay. Now, we'll get back to that. Put an asterisk to that. Amber said she was willing to waive that, but the judge did address it later. So we'll look into that. And then they wanted to talk about, Amber wanted to review interrogatory 11, that she objects to the notion that it is protected by journalistic privilege. Now, number 9, if we go to number 9, 11. In the interrogatories, number 11 says, produce any and all correspondence in which defendants discussed 7M Films Incorporated and its affiliates with third parties. Now, if we go over to the deposition and see 11, because I'm still not exactly sure which one we are, we go back to number 9, which is waived but brought up later. Number 9 in the discovery deposition. Oh, hold on. Oh, this is another part of interrogatory, so this is there. Okay. Yeah, it's produce any and all drafts of social media posts you have made regarding 7M Films. And then 11 is produce any and all correspondence in which defendants discuss 7M Films. Katie's response was, and through her attorney, objection. This document request calls for materials protected by the attorney-client privilege and the journalist's privilege outlined in Minnesota Statute 595.021-025 and Cervantes versus Time Incorporated. Other things in the 8th Circuit in 1972. Okay. Side note, I think this is a problem because we don't have case law for social media. We are citing case law that happened 52 years ago. That is why I watch this case with special attention, because I think that there could be landmark rulings here as it pertains to social media, defamation, the freedom of speech consideration, etc. When you're citing case law that's 52 years old, we have to see if it aged well. I guess that's what we're going to say. So we go over here and it says defendants do not know what affiliates means with respect to this request, because now we're playing dumb again. Remember, we don't know what the big words with 2 syllables mean. So without waiving any objections, discovery is ongoing and defendants will produce non-privileged material once it has been identified. Okay, so we've got the definitions of what they're talking about with 9 and 11, because they were going pretty fast when we were doing this. Now, Amber said right there that the objection is not valid, that she objects to the objection, let's say, excuse me, because it is 7M's position that they do not believe that Katie Joy is in fact a journalist. And she did a strategic move here. She said, if we're going to play that card, that if she is a journalist, which we do not believe, and we do not believe, that still would not qualify under journalistic privilege. And she says, okay, if you're going to quote Cervantes versus Time, then we are saying that in Cervantes was indeed a journalist. And he referred to a public figure. If we say that, we say this journalist for Time magazine referred to a public figure, then if so, a journalist would still have a privilege log. A responsible journalist would have their sources, and each and every phone call, etc., would be there. They would have an entire log of how they did their legwork, how they came about, what they said about this public figure, because that's what a journalist does. So essentially she's being like, okay, let me play your concept out. You still lose the argument. That's kind of the posturing and the mood of it that went on there. Excuse me. I've got all these papers and notebooks. You would laugh if you saw me here. Okay, so then Amber says, in that vein, who did Katie Joy share this information with? That it is their position that false and derogatory statements were spread then, I'm going to insert, by her. Okay. So now Amber goes to interrogatory 11. Now, 11, we are referring to state the name, address, and contact number of each and every person who provided information to defendants, Katie Joy, regarding 7M Films Incorporated. Robert Shin, Miranda Derrick, and James Derrick. So, regarding Shin and the Derricks, who told Katie Joy what? What's their name? What's their address? And how can they contact them to verify that indeed their statements were made to Katie Joy that made her espouse such accusations? Okay, that's in parentheses here. That's a little summing it up. Okay, fair use, fair use, fair use. Now, in that, Katie Joy's attorney at the time of the interrogation objected to it, remember? Because she said it calls for information protected by the journalist's privilege outlined in Minnesota statute, blah, 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 on Cervantes versus Time. Without waiving said objection, where sources were willing to be named, they are named in the social media posts. And confidential sources are also identified as confidential. Okay, so on that 11, this is where Amber said that she objects to the objection because there is probable cause that you cannot assert or obtain journalistic privilege under the conditions of the disclosure of 595.025 that breaks down to the First Amendment. And that's where the argument was a little cloudy because they were going fast and I lost a detail in there. And it says here, she stated, when an individual is engaged in dissemination of information, it does not require a journalistic privilege because Katie Joy has hundreds of thousands of followers. And this is where, is this where Jennifer Moore got in? Yep, that's where Jennifer Moore popped in. Okay, so that's where Jennifer Moore, sorry. Cross out the last two sentences. There we go. Okay, I'm sorry. It was just where Jennifer Moore was. Okay, so Jennifer Moore started in and she says, there has to be probable cause. This cannot be obtained. This is more than the First Amendment. The conditions of disclosure, when an individual is engaged in dissemination of information, they do not require journalistic, I can't remember where it is, because, and this is where Jennifer Moore said that KJ has hundreds of thousands of followers. Therefore, by default, she must be a journalist. Okay. Side note over here. I think that this is going to be the precipice of this case, is that they are going to go into the definition of a journalist, what a journalist is, what it requires to be a journalist versus reporter versus YouTubian. And I think that that's where this is going to be hung up on. It's going to be. And as we know in the order, the judge said the court has not determined whether or not she's a journalist. So much of this is hanging on, well, she's a journalist, so she doesn't have to. Whereas, even if she's a journalist, journalists have ethics and standards. Okay? Jennifer Moore, that's where she was saying, she covers fundamentalists and sister wives. And so it's just part and parcel that she would cover Shin. That's where the part and parcel came in. Okay, now I'm remembering, I'm back in that courtroom with that. Okay. And she said that there are the factors for Bauer. There's the Bauer factors to be considered, that in Minnesota, in Maplewood, there was a case, and it was implied that essentially that question was to create more defendants. That they're saying that if Katie Joy gives up who told her that, then essentially those people could be named in the lawsuit as well. And that's where you have to look at and see if there's a prima facie argument for malice, if the nature of the statement is false, if the confidential source, if there's compelling information, if there's an alternative source, something under Bauer. And I don't have Bauer pulled up right now. And then Jennifer Moore cited something from Channel 11 with the Ramsey County that Bauer, it was at Bauer's work schedule. So that's what they were talking about. Okay, now I remember. So they were basically saying that there was an article in a local newspaper that cited worker, whatever. Okay, so here we are. In the Star Tribune, Jennifer Moore argued that if 7M interrogatories are more specific to who they want from the confidential aspects of everything, then yes, they could be willing to oblige, if you will. But if these things are so non-specific and they're general, then no, they're not going to. They're not going to allow essentially a fishing expedition to get her in more trouble, essentially, was the gist of it. In other words, you're not going to give them anything. They're going to fight for everything. So then, Amber gave demonstrable evidence in saying that, this is one where you might have heard me talk about before, where Amber said, hey, look, yesterday I wanted to find information about the Gaza Strip. And my purpose in so doing was because it's important to me to know what is happening there because my friends and I are interested in it. So that was her point in going and looking up what was going on in that certain topic. Her friends, it's an important topic. It's something that mainstream media was covering, just before Christmas. And Amber's point is, then if she is looking up a topic because it's relevant, it's a top story in mainstream media, it's relevant to her cohort of friends, and so she's looking at it because it's something that then she'll be able to better talk to if it's brought up with friends and they can talk. Which espouses the question, why does Katie Joy post? Why does Katie Joy post about Josh Duggar in particular? Why does she post about Cody Brown in particular? Why Robert Shin? Why does she have an interest in Robert Shin when, if you can say that she covers Sister Wives and TLC, so it's part and parcel that Shin? Well, let's go back to the electric company. One of these things just doesn't belong. Can you tell me which thing doesn't? That thing where it's like, okay, these three things. Robert Shin does not fit into part and parcel, but that's just me. I'm just sitting there in the benches behind. Okay. And Amber stated that it is their plea that there's actual malice, that by stating a false piece of information, there's never going to be information to it because you cannot prove a negative. That something that is false is inherently false. Something that is true holds the test of time and can be verified, and you can show how you came to this. You can show the truth or a lie. And Amber then further stated that then it is logical that the privilege log would be relevant. Either way, that whatever it was that made her state the things that she did, she needs to show how she came up to that. Amber stated, it's not like Katie Joy went to the local watering hole and heard some gossip. Okay? Those of you who know what I'm talking about in Hanover, wasn't like she went down to the one stoplight in town and took her horse on down to the Big Bore and got the local gossip about Shin in ALA. Get it? It's not, there is no connection between her and Shin. Why on earth would Katie Joy be interested in Robert Shin? Not part and parcel of what she usually covers. Why does she cover anything? Because she claims, allegedly, that she too was raised in a cult. And so the next logical question, if you're getting to know somebody who says they were raised in a cult, and you say, oh, really? What one was that? Was that the one where they wore the black Nikes and did all that? Or, were you part of the cult there, the Manson? What were you down there in Texas? No. What cult were you raised in? The Catholic Church. The Catholic Church is a cult. I'm like, oh? All right. Whatever you say there. Change your diaper. Anyway. Amber then stated that they are not trying to add defendants. They are trying to get to the bottom of what happened. And, as such, they cited tortious interference for the example of referring to sex trafficking. When they were talking about the Bauer factors and Care 11, then it was easy to go to the other person who was the confidential source or whatever and say, who told you when he was clocking in or clocking out? It's a basic question. So then, in that same vein, if we're going to do there and we're going to use the Bauer factors, then it is logical and assumable to say to Katie Joy, who told you the Robert Shin was sex trafficking criminals? Who told you this? Who told you this? You can't say, oh, my sources. Well, where are these sources? Who are they? Let's just get their name, address, and everything. And if they are saying this, then let's get to the bottom of this, because maybe we're all missing it. I'm adding in here. Here's me talking, because at this point I'm going, you know what? For a person who doesn't know who's walking in here, you could say that, my God, Katie Joy is Joan of Arc of our time, that she is seeing the wrongs and trying to right them. And there is this man, and he is sex trafficking and waterboarding, and oh my God, and she is the only one standing there saying it. And what are we doing questioning it? We are all enlightened population, knowing better, and the Me Too movement and all of this. Who are we to say that isn't plausible, true? How do you know who said it? We're not even supposed to question it in today's society. It should be enough in today's society that a woman says it, so it must be true. Because that's what we're dealing with a lot right now, especially in Katie Joy's world. If you're following it all, shout out to EKC. You've done an amazing job, EKC. You have brought so many things to the surface that a lot of people are talking about, the great points that you have made. EKC, you are doing God's work. Thank you for bringing the truth up. In my opinion, I cannot imagine the personal suffering that those false allegations made against that young man must have hurt him. I better shut up. Anyway. Okay. So then we go over here. And Amber says, it's not just that Katie Joy posts these things and puts them up. She goes and gets involved in the comment threads. Those comment threads are viewed by hundreds of thousands of people also. She's going around doing this. Tabitha Jane says she's essentially going and pollinating. She's putting this little rumor inside of all these other things. She's planting these seeds, so then they go up and they create other weeds in the garden, and you're trying to sort out where these weeds came from when you just put seeds in. That that Amber Stavik said that essentially it's too general, that Katie Joy does Instagram lives and comments like this. She does comments and threads on other creators' channels. It's not just her channel where she's saying these things. That when it comes to discovery, there needs to be legal questions that have answers. If it is her opinion, if it is Katie Joy's opinion that Robert Shin engages in sex trafficking, that's not a thought that's natural. It's not a naturally generated opinion of somebody down in LA when you're in Hanover watching The Sister Wives. That it is in fact appropriate to say who contacted you. Amber stated that if they then go and they draw this all out and it goes to a trial, they're going to need the privilege log then. So at this point, it is absolutely reasonable to see the privilege log. Okay. Now, Jennifer Moore stated that essentially the story broke because of the Derricks. That the Wilking family was the source of something, that essentially this story broke and it rose up. So Jennifer Moore is there trying to paint the story of how her client came about these accusations. Now, Jennifer Moore stated that Katie Joy may have places that she goes for information. Pacer. Anyway, that Katie Joy may have spoken to, found information about Mr. Shin's former employees. She may have gleaned information from previous lawsuits. And that, yes, she posts and she comments because that's part of what she does. But as stated, that being given, she looks at Amber and says she would have no idea how to find what her client has written in comment threads. How would you even go about finding that? So if they can't, essentially, asterisk, if they can't be found, they can't be proven. Okay, this is what she's saying. Jennifer Moore's playing it. She's saying, how would we even find that out? I mean, if she went to other people's comment sections and everything, well, how would anybody even find that? You know, I can't speak to it because I can't see it, and there's no way for anybody to find it. There's no way to find if Katie Joy wrote defamatory statements, alleged defamatory statements in other people's comment threads on their pages. There's no way to know that. Unless people screenshot it and send it to... Oh, I'm going to shut my mouth. I'm going to open my bubbler. That's what I'm going to do. You guys like bubblers? There's antioxidant sparkling waters. So I'm going to drink a watermelon lime. It's going to sound like I'm cracking open a can of beer, but I'm not, okay? Although I'm in Minnesota, I'm not drinking my beer. I'm drinking a caffeinated beverage. Lots of vitamin D and antioxidants in it. Okay, so Jennifer Moore says if there's no records of it, then how can it be? And that is where I ended last time. I got to this point in my 29 pages, and it's 9. So I'm going to continue just a little bit more in this part, because the judge then said, are we ready to go to the next aspect? And Amber said that she really needs an answer to answer 11. And Jennifer Moore said her client did provide substantial answers already to 11. Okay. Now, that is again in that day where she was acting like there was something that she had to do because she was going to leave her dwelling. That is the day that I believe that this happened, where she sat down with her attorney and they did come to these answers in the interrogatories. That is my opinion. That is what I thought happened that day. It may not be. I have not seen 2 days in which Katie Joy said that she was leaving the house. And we all know that it is a big announcement when it leaves Hanover, because what Hanover's population is 3,982. So when a resident leaves it and goes down the street, got to know. Let me see. Population of Hanover. Let me see. What is the population of? I saw it the other day. Let me see. Oh, 3,769. So when somebody leaves the Hanover area, it leaves them at 3,768 citizens. And so, you know, with the kids going to school and everything, the whole population could be down to like 3,000 in an afternoon. Thanksgiving, it might go up to 4,000. Christmas Eve with Santa and everything. So anyway, it's a big thing when she leaves the Hanover area. This is the biggest thing here. You ready? We're going to do Nancy Grace style. Bombshell tonight. Are you ready? The devil's dancing in Georgia. Bombshell tonight. Jennifer Moore said. Okay, you guys ready? Yeah, hold on to your diapers. Okay? Pinch one off in the diaper, as the mocking media says. That Katie Joyce sat down and had information sharing sessions with other journalists. I should have been wearing a diaper because about shit it. Because honestly, the notion of Katie Joyce sitting there in a circle jerk with other journalists is implying, number one, that she's a journalist. Implying, number two, that anybody would sit with her and talk to her face to face, because I don't even think her husband can do that. I think he just has to sit beside her, right? Right? I don't think he can look at her directly in the eye, crooked chin area. He has to tip his head. I don't know. But this idea of her sitting there singing Kumbaya and braiding somebody else's hair in a circle fashion in an information sharing session with other journalists is pure blasphemy. Blasphemy. I'm sitting there in the courtroom looking around like, anybody else hearing this bullshit? Because I am about to raise the bullshit flag and go and fly it. Because this didn't happen. There's not a world in which Katie Joyce sat down for an information sharing session with other journalists. And then she said, Jennifer Moore said, and based on the confidentiality agreements within that, then does it go to actual malice when it's a company, because companies keep confidentiality agreements, and so something about what they would need to appear, and that Jennifer Moore essentially was saying that she couldn't share these notes with the other journalists or provide the notes that this session in which other journalists sat down with Katie Joy, because she said basically that the practice is not neat. Okay, essentially, you don't want to know the way the sausage is made, folks. Okay, that this information session's going on with these journalists, it's not a neat practice. That, you know, there aren't these notes, there aren't these confidentiality, there's not these logs, there's not these privilege logs, there's not this organized things. It's just not neat. It just don't look at what's going on there behind that curtain up there. Don't look. Okay, this is the kind of thing that is going on in that corner room, and my blood pressure probably like shot way up because I'm going, it didn't happen. You are painting a picture of something that did not happen. Okay? So Amber, pauses a moment too. I'm sure that she's like, is she really trying? Is this real? Am I in the upside down world? Yes, because it's YouTube and it's the upside down world where drunk driving is normal. And if you speak out about drunk driving, then there's something wrong with you and you're going real life. And that, God, don't get me started on what YouTube allows and what YouTube doesn't allow, because I'm not in a good mood about it right now. Too soon. Amber says, okay, well then, you just admitted that this information session occurred with these other journalists in which Katie Joy was a part of. And she kept a straight face. She says, if this happened, then okay, by the letter of the law, by what we are saying here in this discovery process with the interrogatories, then okay, we are entitled to know who was a participant in this journalist sharing session. And if it happened, then in fact, that is an answer that essentially, paragraph here by Tabitha Jane, that essentially if it happened, then okay, then that's your answer. That, okay, here are the other people, here are the contacts. We were in this journalism sharing group. We were all in this little think tank, and here is who is in attendance. This is their name. This is their address. This is their contact information. Call them. They will tell you that I was there, that I was the pivot man in the circle jerk, and there you go. I mean, honest, Amber didn't say that. That's Tabitha Jane saying it, because Tabitha Jane can say that because she's not registered in the bar. Do not quote anybody of saying that. I said that because this is what I'm then imagining while I'm in the court thinking of this circle jerk there, then Katie Joy being the pivot man, because there was nobody else there with Katie Joy. All of the sources are in her diaper with all the other bullshit, because this did not happen. It didn't happen. All right. So she just calmly says, who was there and who were these other journalists? Because then that is your answer. You know, just give us the names and the address. And she said, then if indeed there were confidentiality agreements with these other journalists in this circle jerk, in this session, then the judge can review that information that would indeed be the substantiative answer to this interrogatory question. That if there is a concern about confidentiality, that's what the confidentiality agreement is in here for. Boom. Do you know what I mean? I mean, slam dunk. That's the way I saw it. It's like Amber is like playing the games of manipulative child. The manipulative child we all know is Katie Joy. And Jennifer Moore has the unfortunate client that she has, in that she has to defend this petulant, manipulative child. And Amber is like the responsible nanny, Xena warrior princess, just looking at everything that's thrown at her and being like, all right, you want to play? Well, okay, here you go. If this little circle thing happened with all the journalists, who are they? When did it happen? Was there s'mores served? What happened? Did you take pictures and post it all over and a bunch of journalists all sat around and decided this? This is, okay. Anyway, Amber says, the judge can review it, but that means that it must be answered. That she is holding firm on that it must be answered. Okay? And that is where we are still really arguing that point. And it goes to this maybe being one of the other key elements of this case as it's coming together, is really finding out who, what, when, where, how, and if it was in this journalistic sharing session, when did it happen? Who was there? What did they say? How did it come about that was it? And if we then look, because if, as Amber said, even if it's like a company or something, even if a company has confidentiality, they would still need to appear and put that through to the judge. And I mean, Jennifer Moore then didn't really have a way to get out of that. Amber boxed that argument in, said, okay, then, well, who are they? So Jennifer Moore pushed the point, and she said that there are journalistic standards, and that Ms. Paulson may not have publicated what she said. She only posted about this. Did you get that? That now, Lil Miss played dumb and doesn't understand big words, Jennifer Moore, is trying to bifurcate the difference between publicated and posted. If you've ever been in an argument with somebody who does this, it's like a person just saying stupid things just to wear you down. Alligator wrestling, wear the opponent down. This is Jennifer Moore's strategy. Okay? And on the surface, it's frustrating because it's wasting time. It's insulting intelligence. On the other hand, she's defending a petulant child. And everybody deserves a defense. Jennifer Moore stated that their practice was unfamiliar with how to deal with the posts. And they had to come together with a solution now that they have their Google alerts set for Katie Joy's posting. So when Katie Joy posts anything, her attorney sees it because her attorney entered this century and has her Google alerts set to be notified when her client posts. Now, she said, Jennifer Moore said, if Katie Joy was just a person in posting, it'd be different. And she said something like, people can say horrible things on Facebook about others. It happens on social media. It is what it is. And if Katie Joy was just a person putting these things on there, what's the big deal? I mean, it was just basically trying to distract, detract, create something. You're going, okay, everybody goes on social media and writes things. So what's the big deal? And Amber stated that defamation does not require publication. Defamation only requires that it was stated, posted, otherwise disseminated to a third party. So Amber didn't entertain this other shit cloud. She just went through and went to the basic question where, well, Miss Paulson may not have publicated anything. She just posted it. I mean, don't people go on Facebook and write horrible things about everybody every day? Amber says, no, that's defamation. And defamation does not require publication. Defamation only has the requirement of being disseminated to a third party. Okay? Now, that pretty much covers 11. Let's go and see how the judge ruled in that aspect of Interrogatory 11. Let's go over here in this big Betty binder. All right. The judge ruled. Well, that's the judge's ruled. Okay, so this is the judge's ruling. There's a 5-page ruling. Okay, so you know what? I'm just going to go into the background here, and we'll go into the thing right here. We'll wrap it up by doing this. Because the judge came through, and she said, well, this is what's actually said. When all of the things were argued, she cut it for the day and made this motion. So we'll go here to where she was. Because the introduction essentially was where we've got the plaintiffs being 7M, Robert Shin, Miranda Derrick, and James Derrick. And we've got the defendants being Katie Joy. But she likes to call herself Catherine, and she likes to say that she's also without a crystal ball. But we all know it's just Katie Joy. She's the defendant. There isn't even an S. It's just her. Anyway, the introduction then for the reply memorandum supporting defendant's second motion to compel. Second motion to compel, not the first. The plaintiff's response to defendant's second motion to compel misstates the burden of persuasion with respect to motions to compel and ignores the substantive content of defendant's motion outlining the efforts made to narrow the issues for the court. Okay, now did you see that? Plaintiffs. That's 7M, okay? So plaintiff's response to defendant's second motion to compel misstates the burden of persuasion with respect to motions to compel and ignores the substantive content of defendant's motion outlining the efforts made to narrow the issues of the court. Okay, that looks like the judge does a little give and take. She says, okay, you argued this, you argued that, I'll give you this, I'll give you that. You didn't do this, you didn't do that, okay? The judge started a sentence with the word it. So that's where I couldn't just tell you because she referred to it. I'm telling you, if I ever started a sentence with the word it. Anyway, it also ignores the fact that the plaintiffs have failed in their own obligations to secure their rights under the rules. Okay. Plaintiff's response to defendant's second motion to compel is wholly consistent with an intention to prevent defendants from defending a lawsuit that was likely brought as a strategic. Am I reading this right? No. This is so confusing. Okay, in the introduction, who is saying this? In the introduction here, what is this? 7/25/2023. What is this? What am I looking at? Why is this dated 7/25? Four, 3, 2. One. This is so confusing. Filed in district. Reply memorandum supporting defendant's second motion to compel. Civil. July of 2023. So they're referring to the, I don't know, because the judge's order signed motion to compel. This matter remains set for a live scheduling conference on March 19th. I don't know. I can't figure this out. I think that I'm looking at the wrong paper, and I can go to the, I don't know. And this is what this mess is. I have papers all over Okay, that's what it was. I was looking at the last one. Okay. I wish I could edit because there we go. That was the one in July. I apologize. So then where is the judge's order for the outstanding interrogatories? What is... I have thousands of pieces of paper. I couldn't even do this by the phone so you guys wouldn't see my... Dated 1/29/2024 in the order. Okay, I'm just going to go to the end because I don't know if I put two motions because I don't understand why it's filing. I've got to... Okay, I'm going to go to the last page of it because it says here where I can see that there's an actual date. Okay, because the March 19th was then pushed to April 11th. Okay, that's why those two dates are. That's why this is not filed in this. My God, I need an assistant. Okay, I'm just going to go to the okay. Basically, the order stated in that hearing, and we'll go back to the other things because basically all we covered here was 11. So we're going to say, the order states, plaintiff's motion to compel is granted with respect to all disputed interrogatories and requests for production. Okay, so I must have been quoting what Jennifer Moore was saying and not the judge in this, where I put it together to, I don't know. All right. Because then we go to number 2. And we say the defendant's motion to compel is granted. So the plaintiff's motion to compel is granted with respect to all disputed interrogatories and requests for production. Okay. Defendant's motion to compel is granted with respect to interrogatories 10, 11, 14, 15, 16, 17, and 19. And we'll get to all of those. Requests for production for 9, 14, and 20 granted in part with respect to requests for production 6 and 7. The remainder of the defendant's motion to compel is denied. Well, how do you have parts of it? I don't know. The parties shall continue to abide by the terms of the protective order ordered on February 7th of 2023, and this matter remains set for a live scheduling conference on March 19th, 2024 at 9, which, as we know, was pushed to April 11th at 11. Okay. Now, a particular note on number 3 here, where it says the parties shall continue to abide by the terms of the protective order entered on February 7th, 2023. So as you all know, that was more than a year ago. When I see it posted that they don't understand why certain things aren't showing, that's because that protective order is there. While the protective order can be put in place by either party, it was Robert Shin's attorney, Amber Stavik, who put that order there. Because we all know that if they would not have put a protective order in place to protect Shin's answers and the Derek's answers, Katie Joy would just be making content on this. She makes money off of these lawsuits. She makes money off of everything. I'm pissed off that I lost my $30 to $100, and I have, 2,700 subs. Do you know how much money she makes a month on her lies and actively breaking terms of service each time? All of the rules that you are under for YouTube to have monetization are ridiculous. None of us should have a channel based on the rules. So my posting of the manifesto back when, 10 months ago, do you think that that compares to what she said about the loss of a child recently? When you put in a video on YouTube and you're monetized, there are several conditions that you certify that you do not have in your video. And one of them, of course, would be the content that she does. So why am I losing the ability to earn $30 to $100 a month when she breaks the rules and can make, let's not even think about how much she makes, and have all of these people then questioning what we do and pointing out any one little mistake when she puts inaccurate information up every day. But people just don't know the difference, so no one's going to call her out on it. Doesn't make sense, does it? It's the upside down world. It's YouTube. And when I saw that the documentary is coming out and the things that she's posting about Shin, I'm just disgusted. So that's why I'm back trying to explain more of what's really going on. It's not Shin taking her to court. The initial complaint was filed by the attorney that Shin hired. He wouldn't have known who Katie Joy Paulson is in Hanover with a population of less than 4,000 in the Midwest in any day, if she had not sat there and bit at his heels and ultimately cost him the loss of $4 million in contracts that he had worked hard to secure. Why is it that a Hanoverian with no real world life experience, that does not actively participate in the community, in local events, is not a respected authority, can have the power to cost somebody their job? I can't imagine the discipline in which Miranda and Derek abided by all of their lives to become the incredible dancers. They dance with such precision and grace. How many times did they deny themselves a good meal? How many times did they, not have enough to eat? They couldn't pay for their next meal. They worked so hard and went without, and worked so hard. And they finally get this contract for the Clippers, and some person in the middle of Little House on the Prairie Land says, "I don't like you. I'm jealous of you. I don't like you. I don't like you. And so I'm going to say that your boss does this and that. And I'm going to contact the people who do advertising. And I'm going to have my cult members, because at the bottom line, you want to find out who is a cult leader? Let's line up the behavior. Is it the Caters? She's acting more like a cult leader than them. And yes, I'll get taken to court for saying so, but you know what? I don't care. I'll represent myself. At the end of the day, if you speak out on certain topics and you're so obsessed with certain things, a person says, "Why are you so obsessed with it?" Because you're learning, or it's what you do, or it's what you fear, or it's what turns you on. Well, what's the give for Katie Joy and why she reports on Robert Shin? Is it that she's getting money for being a part of a documentary that was in the making? Or is it because she likes to have people follow her and not ask questions too, like a cult leader? So she accuses other people of being cult leaders because they have people that work for them and with them. That's not a cult. That's an employer. That's a talent agent. That's what they do. And you would know that if you had talent that you had worked a lifetime to earn and be on stage and be seen as a thing of beauty, precision, and grace. But you don't. You sit there in your chair, not actively being involved in your household, your son, your parenting, your marriage, your pets, your yard. If other people do it, so you can sit there and make money and get off when you cost somebody their job, it's not the way I want to make my money. I don't, I wouldn't. And I think it's disgusting that you do, Katie Joy. And I know that she listens, so like I say, it's rather rich coming from you acting like Robert Shin has taken you to court. Again, he's not the one on trial. You are. You're in trouble for your mouth. And that's the bottom line. Thank you for listening. I'm sorry I wasn't showing the paper, so you would have seen where I get confused and everything as well. I hope that you understand that I'm doing the best that I can to get the facts and the truth out here, because God damn it, somebody needs to. And I can say that now and I'm not monetized. Thanks for listening. Please give me a thumbs up, and in the comments, let me know what you did while you were listening to my video. And I hope that I gave you the energy and the inspiration to have a great day, a better day, and that you did something productive while listening, that I gave you the energy to do so. And if you're so inspired, please tip me at my Cash App, Tabitha Jane 13. Thanks for listening. Share my work too. That'd be awesome. Thank you. Bye-bye.